Lou Mosca, Chief Operating Officer of American Management Services, and on this edition of Straight Talk, I want to talk to you about intellectual property. So I had a friend come to me recently and say to me that she believed that her job, her duty, her role at the company she worked for was her intellectual property and not to be shared with any other employee in the organization or her employer. After I was done chuckling my head off, I said to her, Jen, come on, you're teasing me, right? And she goes, no, absolutely not. I refuse to train other people. I refuse to work with other people. What I know and what I've gleaned over these 5-10 years that I've been working there is my intellectual property. To which I said, you're out of your mind. When you cross that threshold and go to work for wherever you go to work, so let's say you come and you want to work at American Management Services. Anything you develop or create or your normal tasks, your normal role, are the property of American Management Services. Someone comes to work for you in a restaurant and they come up with a better idea of how to move things through your kitchen. Isn't that for your benefit? So folks, intellectual property, I love the phrase because I think what Jen was referring to really wasn't intellectual property. It was more about job security because they didn't want to share things. But everything you do when you hire an employee belongs to you. And don't be afraid to demand that. It's part of the reason we suggest people sign non-disclosure agreements and non-compete agreements, which spell it out for us pretty clearly. Okay, so if you want to talk about it, give me a call. But this straight talk tip of the day is really simple. Don't confuse intellectual property with your just normal job duties that you're getting paid for. And what you're getting paid for belongs to the company that's paying you, not to you. Have a great day.